the Costello case really sets this out in great detail, Your Honor. In that case also there was in vitro testing that was used. And the court recognized that in vitro testing is not scientifically accepted. But yet they allowed it and said it was proper to go before the jury because, again, it was a jury question and the defendants were objecting to the conclusions, not the methodology to reach the conclusions. And that's precisely what's occurring here with the defendant appellees in this case, Your Honors.
So if you take your argument to its natural conclusion, it seems to me that we ought to just do away with Fry and let the jury decide. Is that a fair statement?
No, it's not, Your Honor. Absolutely not. And we would cite this court to pages 31 and 32 of our reply brief. And what we did is we listed over the past 15 years where Fry had applied under Florida law in all different cases. And there's always some type of a test, whether it's the systolic blood pressure deception test, the DNA test, statistical profile, post-hypnotic testimony, knife comparison test, sexual offender profile test. I mean, you can go on and on. There's always a gadget. And this gadget, if you will, this scientific evidence that is now interjected, then triggers the Fry policy for examination.
Counsel, let me ask you, in my mind, I guess the question really comes down to this. Is the ability to diagnose the existence of a medical condition the same as being able to state in some sort of a reliable manner what the cause of that medical condition is?
I think those are two separate issues, Your Honor, but they can be one and the same.
Well, but in this case, aren't they really two different things? Yes, she has fibromyalgia, but is there some scientific, well-accepted body of evidence that would say that if you have this trauma, then there is a substantial likelihood that you end up with this condition? Or is the jury just supposed to depend upon the expert who comes in and says, I'm an expert, I'm credentialed, I've treated a lot of these cases, and I have observed, in my opinion, a great correlation between traumatic injury and fibromyalgia. Should juries make that determination based upon one expert's? I guess I'm trying to distinguish between pure opinion and just coming up with something out of the air.
Your Honor, if an expert comes out with something out of the air, that is completely subject to cross-examination and to scrutiny by the opposing counsel. And that's the very point, just as any other witness would lie or make something up. But when that expert relies upon scientific evidence, that brings it into a whole other realm.
Well, doesn't every expert, at least in your case, doesn't your expert rely on scientific evidence? I mean, where did he get his medical training? Presumably that's based upon science. I mean, he didn't just make up everything he knows, and presumably he has continuing education requirements and reads journals and that sort of thing.
Your Honor, there is a diagnostic test called a SPECT scan. It's a single photon emission. It's the latest, greatest diagnostic tool. And some rheumatologists are using it to diagnose fibromyalgia. Had Jill Marsh been subject to a SPECT scan, and had the expert relied upon the SPECT scan in making its diagnosis about post-traumatic fibromyalgia, that is precisely the type of test or technique that would be subject to Fry. However, that was not the case. And to more specifically address your question, I think it is addressed more specifically in Geldstorp versus Weinstein. This is a second DCA case in March 2nd of 2005. But here the expert relied upon a certain study, or actually he cited it in his testimony. And the court said just because an expert cites a study that's consistent with his opinions doesn't mean that he relies upon it. And certainly every expert, I mean, we have two of the foremost experts on fibromyalgia in the world in our case, and both of them have written extensively. They've done studies. They certainly can't remove that. But they didn't rely specifically upon some certain things in their testimony, nor would they at trial, which we didn't get the opportunity to do, in order to render their opinions.
Counsel, the problem that I'm having with your argument is it seems to me when they moved for a Fry hearing in this case, is what I understand happened, it seems to me that at that point the trial judge is obligated to listen to the evidence or depositions or whatever else is available and make a decision as to whether or not it's expert testimony or it's that his testimony is flawed because of reliance on scientific evidence that's fanciful and so forth.
And
then making a decision as to whether or not that evidence is going to be admissible.
well, Your Honor,
Because you, I think, conceded that if it's not based on well-established scientific methods, that it's inadmissible.
Your Honor, the error of the trial court, which incidentally did not have the benefit of Costello and its progeny when it made its first ruling, had it had that case, we don't believe the trial court would have decided in the way that it did. But had it had that case, it would not have even applied Frye to begin with. And in fact, if you look at the transcript, once the judge reads State Farm versus Johnson, which is a case on all fours involving fibromyalgia, post-traumatic, and the second DCA, where they said, Frye doesn't apply to this testimony. He said, I had an epiphany in the transcript. And he basically realizes that he should not have applied Frye to begin with in the case at all. Your Honor, the standard of review in this case is de novo, and that means that the court should look at all of the evidence that's available at the time of the hearing.